Okay, well, welcome back. We're going to hear a few final remarks from our panelists before we open it up to their questions of each other and your questions of them. So, David, if there's anything that you would like to add to what you already have talked about this afternoon, please do. Just a few minutes.
So this is, I guess, a rider to my opening remarks, rider one, because one of the very important issues that I did not have the opportunity to talk about are some state initiatives in Arizona law and the Alabama law, which targets not employers, but targets the supply side, namely the employees. So some states in these restrictionist areas are crafting legislation which says that an employee who's unauthorized to work in the country can be sanctioned. And the question there, again, is whether or not IRCA preempts these state initiatives. Some people think that these are the most likely of the percolating issues that are coming up right now to survive, and other things that they're the most likely to fail. And so I want to talk about this because I think people are coming at the issue from different perspectives. Again, going back to the preemption taxonomy that I had on the board before, probably would be helpful to, I don't even know if this is still loaded. Yeah, there it is. That was really convenient. It's like I planned it. You know, I think looking at this, we could talk about whether or not these types of initiatives are field preempted, meaning that, you know, Congress in IRCA passed a statute which expressly said that states and localities cannot create sanctions on employers. And the question is whether or not, in not saying anything about whether states could impose sanction on employees, whether or not Congress has intended to occupy the entire field. And what we have in this example is a congressional silence, because Congress clearly said that states and localities cannot sanction employers, but didn't say anything on the issue of whether or not states and localities can sanction employees. Also, the savings provision is not going to save them here, because no one is claiming that this is a licensing law. What they're arguing, the states, is that this is not field preempted, because it all turns about how broadly you define the field. And so what the restrictionist states are arguing is that Congress intended to occupy the field of regulating employers, but was silent and didn't say anything about what we could do about employees. So a couple of observations here. You know, Congress could have created an express preemption provision just like it did with respect to employers. Right? It could have said that the states are prohibited from sanctioning employees, just like it said expressly that states and localities cannot sanction employers. And so the absence of that express provision as it relates to employees really opens up the argument that, listen, if Congress knows how to preempt, it just did so with respect to employers, and the absence of a similar or parallel provision with respect to employees means that we can do it. Again, touching on some of the themes that I talked about from Whiting, what might Whiting tell us? Well, if you look closely at the legislative history of IRCA, I think, in my opinion, that it's fairly clear that Congress made the decision to not target employees. You know, there was a discussion, should we target employers, should we target employees? And in that discussion, it's fairly clear that for humanitarian reasons or for other reasons, Congress made the decision, thought about it, and made the decision to target employers. However, you know, if Whiting tells us anything, it's that the court is not going to look, or at least is going to look skeptically at legislative history. And so the best arguments in favor of preemption are found in legislative history. And so again, it's going to be important to see how much weight a majority of the court gives to that legislative history versus sort of the structural arguments, which I already identified, which is that Congress knows how to preempt, it did so for employers, but didn't do so with respect to employees. The other little point I want to make here is that in being silent, it's possible that Congress intended to occupy the field, but it's also very possible that Congress intended to not decide the question, to let states experiment with the regulation on the employee side. And in my closing seconds, I just want to point out a very important irony that I hope will be the subject of some more discussion on this panel as it relates to federalism. There's a strong movement to keep states out of regulating in the field of immigration. One of the values, or the so-called important values of federalism, is it allows the opportunity for states to experiment, to see if different systems might respond in a better way or a different way than the federal government might propose. And going back to IRCA, the 1986 statute, that's at issue in Whiting, and that's going to be at issue in these other employment-related cases. That statute was built on and modeled after the states. So when we talk about leaving states out of the equation, a lot of times there's just a knee-jerk reaction because we don't like the policy that the states are choosing. But in terms of a dialogic function, there could be potentially some value in the experimentation that the states are doing, and then now Congress can look to see whether or not sanctioning employees results in undue discrimination, or whether it creates other types of racial or other types of problems on the one hand, or whether or not it turns out that in practice it's an effective way to regulate the employment side of immigration. So that's all.
Thank you, David. Juliet?
So I'm going to try to actually tie the E-Verify talk that I was giving a little bit actually to the first panel and to David's talk about preemption. So wish me luck. So when I think that we can think about this state and federal involvement in the E-Verify system is it's sort of immigration law having a feedback mechanism between respect to the federal and state government. And I think I suggested and sort of pointed in that vaguely in the direction of that at the beginning of the talk. But one way of thinking about it is this, right? When states mandate the use of the E-Verify system, one thing that the states are doing are basically putting more employees into the pipeline, to that federal pipeline, right? Putting more employees to that federal government database, but also as a result, sending more employees to the Social Security Administration, Department of Homeland Security to get fixed, right? To have their employment documentation problem solved. And if you look at the way that the E-Verify system has been implemented by the federal government, started out as a very small pilot project, and then grew sort of slowly, incrementally, to be a much larger program. And the got a new name from basic pilot to E-Verify. And in the meantime, through feedback from the GAO and groups, other sources, the federal government has been basically trying to fix a bunch of these problems. So we went, for example, from an 8% tentative non-confirmation rate to this 2.6% rate that we have right now. So what we're seeing right now with the state participation is the states are not just pushing the federal government one way or the other through just sort of politically what they're choosing to do, but they're also pushing the federal government in sort of a reactive way, because the federal government now has to react to the employees that the state is pushing to the system. And I want to sort of relate that to the discussion we were having this morning about state and local law enforcement participation in immigration enforcement. And this tension, and I think Chris Kowak particularly articulated between having state and local law enforcement officers basically sort of feeding suspected undocumented immigrants to the ICE, right, an ICE system. And the question of whether that overwhelms ICE's ability to make prosecutorial discretion. Peter Vincent sort of thing, I think especially that was that over lunch. So in thinking about this, the way that the states can act in ways that might change the federal government's priorities, right, and its own discretion to undertake some of these federal programs, I think those kinds of arguments are arguments that can feed into the kinds of preemption arguments that David's laid out.
So I've got a little bit to add, and it kind of connects up a little bit with to the extent to which the establishing E-Verify and also the broad sort of debate about federal preemption is to the degree to which our preoccupation with immigration law may actually start impacting how we think about labor and employment regulations more generally. And what is the concern here, I think, is to the extent to which we interpret the federal immigration powers very broadly, or we think that in order to enforce federal immigration laws, we should allow the federal government status, all sorts of database requirements from employers, how that actually may lock in our debates about experimentation in the world of labor and employment practices. Here I want to give two examples, right? The first one is Hoffman Plastic, recent decision, early 2000, recent decision that was created. In that case, it presented a conflict between the National Labor Relations Board and the Federal Immigration Statute. What was interesting in that was you had an undocumented immigrant who was fired for unionizing activity. The NLRB said that is true, he was not authorized to work, yet in order for us, we think, in order to make sure that employers are sanctioned, right, for trying to get out of unionization activity by firing people and not giving them incentive to hire undocumented immigrants as a way of avoiding this, right, unionization possibility, we're going to have to reward that thing, right? That's the only monetary sanction it had. The other one was really weak. I mean, it's pretty busted up, but it was like, you have to give, like, a notice of rights to all your employers that you have, saying these are your rights, and then you have to say, I promise I won't do it again. The back pay seems to be the big one, right? And this is sort of actually hurting the pocketbook. And here, the court, I would suggest that actually this was an open question. I think the dissent expressed that as well. But the court essentially said, we have a very strong interest in federal immigration enforcement. The federal power is very broad. And in this specific case, it overcomes whatever the NLRB has to do because it's really not about labor and employment. What I want to sort of push beyond that, because what I think, especially in the state context, is I think actually a lot of state localities are trying to experiment with different ways of regulating their labor market. But in some ways, they may be facing up against concerns with regards to federal immigration restrictions that may be actually hampering their independence to experiment. One very controversial development is with regards to establishing day labor centers, right? A lot of localities who are very concerned that, putting the immigration issue aside, right, very concerned that there is, that a lot of it is happening under the table, that the day labor market is prone to exploitation, that may actually be paying a lot less wages because there's sort of no organization, has thought that the best way to do so, and to just get people off the street, right, I mean, sort of congregation and they litter and stuff like that, is to set up day labor centers so that the labor market of this highly unstable workforce is more regularized, right, that you go to one certain place, people line up, we know who's getting paid, everyone's registered. But because day labor centers have the possibility in many cases serve undocumented immigrants, a lot of those moves have been sort of challenged and struck down, mostly in the policy arena at this point, because it helps undocumented immigrants, right? Because it aids and abets undocumented immigrants. Now, I don't want to say that that's not a legitimate concern, but we have to think about, to the extent that we want to sort of not aid and abet undocumented immigrants as much as, in any way possible, how far are we going to stress that in such a way that we may actually hampering other concerns that we may have within sort of trying to regularize the labor market, just because this thing has sort of gotten so big and the federal government power has expanded in that regard. So I just wanted to put that out there.
Thank you. And now if we could take a few minutes so that you can ask each other questions before we open it up to the audience. David, again, we'll start with you.
Sure, thank you. I just have a question for Juliet, and which is, it's just a question, because I haven't thought it through, and so, but if anybody has, I think you probably have, which is, you talked about the potential risk with the E-Verify system to the government, and that a lot of these risks are either unquantifiable or difficult to quantify or speculative, or they're not as concrete as some of them anyway, some of the risks that you might hope to have in order to get the type of motion that you need or action from the government. And I was wondering if you can compare the risk that you identify through the E-Verify system with the risk that currently exists through I-9, because it wasn't clear to me whether you're suggesting that the I-9 system is less intrusive into that working relationship, or that it is, but it's better, it's somehow still better than E-Verify. I was wondering if you could clarify that.
Okay, so thanks, because I think that's a really a good question and a hard one. And here's what I think about that, because one of the things that I've been trying to figure out is whether whether there are harms that are unique to E-Verify that don't come about just as a result of the Immigration Reform and Control Act. And I think there are. I think one of the things that we see with E-Verify, for example, is this idea that the government is now in making that decision about whether to retain this employee who's been recently hired in the last 3 days. That the government basically has kind of a veto power, whereas I think it didn't before under the I-9 system, the employer sanction system, as a result of IRCA. So, in other words, under the I-9 system, right, you did your I-9s, you put them in your I-9 file if you're doing what you're supposed to, right? And then later on, if the government SINUS, then INS, now ICE, was interested, they can come and audit those I-9 forms, and there was a provision in the law for that. But what you see with E-Verify is the instant and individual decision-making that's going on from that government database. I think also the harm can be, or the E-Verify system empowers the employer more than the I-9 system does. Because the employer is now able to get basically somewhat more accurate information about whether somebody is undocumented. And so if there's an interest that the employer has, and a scrupulous employer has, in breaking up some sort of organizing or concerted activity, they have more information than they did just under the I-9 system through that government database. They don't know 100% whether somebody's work authorized, but they can certainly get a lot more information about it. And the last one, I think, is something that that hits everybody in the little libertarian that lives inside of us all. And that's this idea of how comfortable are we in the creation of databases in which all of our information will be fed to the government. And that's something that, of course, the I-9 system didn't do. It did it on paper, and it got put into an employer's file, but it wasn't something that got transmitted to the government on a daily basis.
Thank you. Juliet, would you like to ask the next question?
I do, and I have one for David. So I love this idea of sort of looking at the Whiting decision and seeing what kind of implications it has, for the future. And so I guess my question is this: the Whiting decision, if you read it, it's a decision in which the author is trying to be very narrow about the holding. It's very narrowly written. It's one of those who are only talking about this case and this particular situation, this law. And we're not sort of trying to make big policy pronouncements about immigration law or anything like that, or employment law. So it's really just about whether this one statute preempts what Arizona is trying to do. And so I wondered if you could talk a little bit about, given that effort on the Supreme Court's effort to really try to craft a narrow decision, is that going to have the effect of kind of curtailing the effects of that decision in future cases?
That's a great question, and I hope that I was clear to say that I can't promise that Whiting has sent any strong messages one way or the other precisely for the reasons that you're identifying, but that if it does send a message, it looks to be, it's not helping the challengers. It's either going to be neutral because it's as narrow as Chief Justice Roberts intended, or it's sending hints that the court, either because of the surrounding political climate, is going to be more responsive to a state role in immigration than, say, it might have been 30 years ago. If somebody had asked me 2 or 5 years ago whether or not states had a role in immigration, I would have said no. But now all of a sudden I find myself not only saying that they probably do, but that role might be significant. And I'm not suggesting that if I was a justice on the Supreme Court that I would uphold these laws. But given the makeup of the court as we have them, and given the political climate that these cases are arising, and I think that there is a significant chance that a lot of these initiatives are going to survive the judicial challenge. Now, back to my slide. Because it's true that one of the issues in the case, and an important issue in the case, was interpreting the express preemption provision in conjunction with trying to determine how broad the savings clause was. And that argument was made and rejected. And if we get any indication from that, the disposition of that issue, is that the court is going to engage in textualism. And so I don't know how that impacts other issues that are percolating up, because there's not, these other laws don't really involve express preemption provisions. However, after it rejected the express preemption challenge, it then went on to decide the implied preemption challenges, because under the Supreme Court precedent, the existence of an express preemption clause or an unsuccessful application of an express preemption clause does not preclude the possibility that Congress impliedly intended to preempt, even though it wasn't expressly presented. And so, while everybody thinks about Whiting as an express preemption case, it was very much also an implied preemption case, because the court had to address those issues. It wasn't dicta. The court had to dispose of those issues. And in the context of addressing the implied preemption question, I think that there were some clues that could extend. Things like how receptive the court is going to be to legislative history. For example, how receptive is the court going to be to the upsetting the balance arguments that the opponents of the laws are making? How receptive is the court going to be to Chris Kobach's mirror image theory? Again, where according to Chris Kobach, as long as the state initiatives essentially track the definitions in the federal laws and don't create any new categories of immigrants, then perhaps that's a recipe for avoiding a preemption challenge. Now, the court hasn't guaranteed the success of that theory going forward, but again, it was at least receptive to it and inciting the ways that the Arizona statute at issue matched or tracked the federal law, at least shows that the court is receptive to that. And almost all of the other state initiatives that are on their way up share that important feature, because Chris Kobach, as the architect of many of these laws, that was his thing. Let's follow this recipe, and if we do, this recipe of tracking the federal standards, and if we do, we'll have a much better chance of success. So it's not that it's a guaranteed winner, but the court has shown signs of accepting that as a basis for showing at least a tolerance for these laws. And also, the upsetting the balance arguments that the government presented, or that the U.S. Chambers of Commerce presented, don't work in Whiting. And it doesn't mean that no upsetting the balance arguments are going to work, but again, the court is open, or at least seems receptive to the fact that the states have a role in helping the government achieve the balance that the government had in mind. And so that's how I think that Whiting has future implications, notwithstanding what otherwise might be a narrow case.
Rick, do you have a question for either of our...
I actually have a question for both. So it actually was triggered by, I think, David sort of bringing in the federalism argument, right? There's sort of, we have certain norms within there. And it got me thinking a little bit about the E-Verify program, because it's actually quite unique, right? You have essentially, so federalism, we usually think the big fear is that the federal government's getting too big, it's preempting states, states are getting sort of suppressed and they're going to get pushed down. But here we have the federal government decided, for many reasons, we're going to establish a pilot program. So we know this is not ready for full deployment, right? And we have this timeline, and we're developing it, and we're putting money into it, and people are crunching numbers, doing whatever they're doing in the background. And here we have maybe a reversal of the traditional federalism tension, right? The federal government is preempting the state. The state is sort of, in some ways, trying to force the federal government to do something, right? And granted, it's not forcing them to adopt a state plan, right? This is a little mirror image, but they're essentially trying to force the trajectory of the E-Verify system, right? At the very least, what it's forcing is pushing up the timeline, right? Whatever that timeline is, right? But you can argue that, it may be concerns otherwise, like by sort of mandating it and in specific states with specific arguments, that they may actually start shaping the way that people behind the scenes are creating the federal E-Verify program. So I guess, sort of, at least with regards to the E-Verify program, is there something that we should be concerned about, this kind of development, that state, maybe the pilot program is unique, right? I mean, there's not that many, but I mean, we wouldn't think that the state could somehow push, some new experimental airplane being developed in the military, into full deployment or something, right? It must be at the space. Is there something that's unique about the states trying to do that here? And I guess my second question, more broadly to David, is that when you brought this idea of federalism, and one thing that you mentioned was that actually the employment regulation that we have now at the federal level actually was originally at the state level, right? 14 states had enacted something before the federal government jumped in. We usually think of the argument we have now on preemption is that this is a federal issue, we should all just deal with the federal level. But I think when you look historically, it seems like there's always a back and forth. There's always interaction. Is this something that's problematic, or is this something that's just democratic policy making in a federal system? Like, is it something we should be concerned about, or as you were sort of evincing at the end, maybe something we can potentially or cautiously welcome? So I'd like to hear some thoughts on that.
All right, I'll give this a shot. So yes, I think there's something unique about the way the states are sort of influencing the federal government here. And let me lay out just two ideas. One thing, if you guys take Rick's comparison, do you see states pushing, military development? I'm sure there's some states that would like to get some more military contracts, but I think in particular with E-Verify, what you really see there is the federal government moving into the employment arena. And the employment arena is an arena in which the states have traditionally, historically had police power, in that area. And I think, as a result, I think it's something that movement and operationalized the employment arena means that states see themselves as much more capable, institutionally competent to regulate in that area, and perhaps to kind of help the government figure out how to do this new job that it has of regulating the employment area. So maybe what we might see going forward is states are mandating E-Verify, but also doing that within another context, like adding to it sanctions for employees who work without authorization. Then, these are the sorts of ideas, or the 50-state experiment. The 50 states are experimenting with the E-Verify system, adding a few things here and subtracting a few things there. These are the sorts of things that could give the federal government ideas about what to do with that system. But I also think that the counter trends are important here, because Illinois and California, and let me add in Rhode Island, right, where it has an executive order that mandated employer participation in E-Verify, and then when the new government came in and said, no, we're not going to do that anymore, right? So we're not going to, it backpedaled. So as the states are starting to actually make this thing happen, and are starting to see some negative implications of it, that's something I think the federal government could learn from too.
Rick, thanks for the question on the federalism point. And there's always a danger when states experiment, because people's lives get affected, and those experiments might turn out to be bad. And so one of the things that our state legislatures, and even those that are not in the policy-making position, have to think about is a matter of policy. Is this a good idea? Is this going to result in harms that maybe we don't want to bring upon ourselves? The flip side of the coin, though, is the value of a dialogue that's being created. If nothing else, we're talking about immigration, and we're talking about it at the right time. Now, we could have a dialogue, but through dissenting voices, where people express their views about why this would never work or why this is a bad idea. Or there can be a dialogue that comes through dissenting action. And so and there's a difference. And so what we're seeing today is a dialogue through state and local legislation and regulations, which creates a situation where people have to talk about these issues because of the fact that people are being affected in ways that mere words alone do not. And so I think that when you talk about dialogue and experimentation in the ways we do now, it comes both with potential danger, but it also comes with a potential benefit, because nothing in our country happens without friction. And you could talk about it all you want, but until that friction reaches a level where something has to be done, generally nothing's going to happen. The other thing that I see possibly happening here through this dialogue is that if and when the issue gets to Congress, which it has to, I mean, it hasn't really left, it's just on a different burner every year, depending on what else is going on in the country. But the idea is that rather than having people sit in committees talking about what could be or what could be the right solution and will these approaches work, Congress will actually have a market of regulatory solutions to choose from. And so I do think that there's a value in that, but again, it does come with serious risks, and I think in many ways both are important in this dialogue, and we're seeing that unfold now.
Thank you. I'd like to open the discussion up now to our audience, and if you could come up to the microphone to pose the question, please do.
Don't make me call on you.
I'll get started, I guess. Here. I'm Joe Asher, Symposium from Washington Law School. I'm an employment lawyer. My background and practice before I worked at the National Labor Relations Board, and I was the chief counsel for the Kansas Human Rights Commission. So, I guess my question is to sort of go back in time for a minute. Employment lawyers, because of this 1986 Act, are put in what seemed to be a position that they're not qualified to be in. I remember sitting around the NLRB trying to figure out if this lawyer had proven whether these people were undocumented aliens in a certain case. We had no idea. We didn't work for INS at the time. At the HRC, we trying to figure out whether the statute applied. In practice, you had employers trying to figure out who is and who is not an undocumented alien. So I guess the question is, was the policy choice in 1986 right by putting on employers the obligation to enforce the nation's immigration law? And if it wasn't, what do you replace it?
Thank you, Joe. Who would like to take a first crack at answering that?
I'll try to do a quick job and then leave some room. But there's plenty of room right with that question. So it's a great question. I mean, I think the reason we have E-Verify is we've been struggling with exactly that question ever since 1986. And I think what people have said a variety of things, right? A lot of people have said, right, the 1986 employer sanctions law, the law was a really bad idea because it's had all of these negative effects on employees in general. And it's put employment lawyers in a position where they feel like they're operating in a completely different area of law where they don't, know what they're doing. And employers as well, right? Employers have said we're not immigration enforcers, so we shouldn't be in that position. Others have said, if we're serious about enforcing our immigration laws, right, this was supposed to be a quid pro quo where we provide amnesty for people who are in the United States unlawfully, and fix that, right, so that everybody in the United States lawfully, and then we cut off the magnet of employment, right, to the United States, and we do that by basically introducing immigration enforcement to the employment arena. So, is that a good idea? I think it's had a lot of unintended effects, and there are a lot of arguments that are made now that say it's actually given, it's created a system in which it's actually easier to hire undocumented employees if you want to. Right, because all you have to do is, right, with the I-9 system alone, right, so that's the E-Verify side first. All you have to do basically is make sure that your employee comes with a document that looks genuine, that's genuine on its face. You look at that document, you're not supposed to be a document expert, and voila, you have somebody who you're pretty sure is undocumented, but you've done your job. And so now you have, I think for the unscrupulous employer, right, the law has been satisfied, and you have somebody who you think is undocumented, and you have more information about that than you used to. So, right, but I think the question remains, and this is the tough one, I think, for all of us. If we are going to have, if we are going to make decisions on open borders, we're going to have some sort of restrictions on immigration, and we're going to enforce them. Is there a kinder, gentler way to do that than the employer sanctions provisions and trying to basically cut undocumented employees out of the workforce? And I think it's not what I'm prepared to answer
I want to add a little bit to that and talk maybe more generally, because I think that is a bigger concern with regard to enforcement, and it reflects a certain change of how I think we struck the compromise, right? So as David had said before, for the first 100 years, states were primarily involved in regulating immigration. They had all sorts of ways of doing it, including sort of screening at the ports, but the fact of the matter is none of that was very effective. So when the federal government actually took it over, and it was after states got struck down, states were actually kind of happy, right? Because states are like, we've been trying to do it, but actually we're not in a good position to do it. And the federal government's greatest innovation at that time was, actually we have all these state departments. We have all these consulate offices all around the country. We don't have to do the screening at the borders, right? We'll do the screening before they get on the steamship, right? And I think at a certain point we made a compromise, which is that the federal government is really good at border enforcement, that happens, but that means we don't have to deal with these things within the United States, right? And I think for a long time that lasted. But with regard to the employment restriction, I think the method now is that enforcement has become so big, is that we're always looking for another avenue of instituting enforcement, right? And we've also gone, I guess, what I want to argue, more flexible, right? It used to be, the question is, do they get in or do they not get out? Or do they get out, right? Can we physically block them? But now we're like, oh, well, we balance this amount of incentives and we give these people these benefits but not these benefits, or you have 9 years on, you're a legal immigrant, you have so many years where you can't get any benefits, and here you get, we start tampering with everything in our society, that we're going to create an incentive structure where people are going to do different things. What ends up happening, however, I think, is then you start integrating the immigration dialogue to every aspect of domestic life, right? And where it feels like, maybe because I'm in the field, it feels like whatever I do, local government law, whatever, people are thinking about it. It's certainly the case in employment context. Julia's written about the case in criminal law complex, right, where state court judges, state prosecutors, state defense attorneys now essentially have to be immigration experts, right? Because in certain communities, that's always going to come up, and they may be dealing with some misdemeanor drunk driving issue, but when you have that immigration potential consequence hanging down the line, that overwhelms everything, right? I mean, that's, we can be negotiating some community service here, but then that thing sort of takes over the entire state criminal justice system. So I do think that there are aspects to which we have to think about, and it's a classic argument, but enforcement at what cost? And I do think that in some ways it's intruding at a various level of consciousness because of this fixation on it, and putting lots of people in very difficult positions.
It's a great question, Joe, and my answer is very short for a change of pace. I'm not sure how effective it is to regulate the workplace in terms of immigration, but it's better than building a fence.
Thank you. Thanks for the question. Reggie.
Reggie Robinson, fan of panel. I'll identify myself. Thanks for your presentation. I'm thinking about magnets and hard policy questions, and I'm going to try to form those thoughts into a question that I hope makes sense. This morning, we heard, I think, from Secretary Vermont, and I think Patrick as well, the notion that, at least to some extent, the immigration flow is aggravated by social policy magnets, in-state tuition for undocumented immigrants, the availability of a pretty robust social safety network, social security network, safety net. We have this sort of welfare state magnet that works to pull people across the board. And people debate the power of that magnet. I think most folks think, though, that probably the most powerful magnet is the employment magnet. At least the prospect of employment is the thing that pulls people across the border. And so I think about that as a prominent magnet, the employment magnet. I led, Greg, to your conceptualization of this whole debate around immigration policy as sort of a proxy war, as a sort of substitute for a more difficult debate and conversation about employment policy. And your sense was, if I understood you right, we're having this immigration conversation or debate instead of the employment policy debate, because the you can tell me if I'm right about that, but it seems that we're learning that the immigration debate is really, really hard as well. But what I'm curious about, in terms of your formulation, what about if we decided that we wanted to have an employment policy conversation as a way to get at the immigration issues that are confronting us, instead of an immigration-focused conversation? Because I think that's maybe what you were suggesting might be the alternative, or at least a thought alternative. What might that conversation look like? How might it be framed, especially in light of our current sense that the immigration issue is sort of largely a federal issue, and as Juliet pointed out, the issues around employment and employers and employees in an area where states seem to feel like they really have a comfort level and kind of authority that might not be present. So that makes sense to the question?
Yeah.
Great. So I'd love to hear your shot.
Yeah, definitely. I mean, it's a great question. I'm going to see. I'm going to try to address it the best I can. On the basic level, I think the labor and employment discussion is hard. I'm not entirely sure the reason we're going to immigration is because that's hard, because this is hard too. But I do think that when, maybe connect to my earlier argument, I do think that when we sort of see everything in the glasses of immigration, we start forgetting or overlooking that actually we have also prejudices about labor and employment or different thinking about it, and we miss opportunities or different ways of allocating that we can. And maybe this comes a little bit about to the extent to which an employment policy conversation may actually help. I can't address all of it, but I think there are some ways that we do. I think there's a very complicated question between my three models. I mean, look, collective labor and unionization, there's a lot of literature now actually out there, and a lot of developments where immigrants and undocumented members are actually being organized, right? And that's been sort of the policy going forward. But the fact is, labor is a very contested realm in today's labor and employment policy. I was talking to Julia a little bit before, even with substantive rights, it's a very difficult question to the extent to which how much is employment discrimination or other sort of substantive rights are being protected, raising the minimum wage, those things are all very contested questions. I do think one area where the employment focus may actually change our immigration conversation, this is a little bit different, is to recognize that actually every state and every region have very different employment and economic needs and interests. I mean, one thing that's fascinating about the Utah law, and you see it in some of the debates in like South Carolina or whatever, is that, so the Utah law, if you don't know, right, so, never thought they're just going to come out and copy Arizona, but they come out with this interesting legislation where on the one hand we're going to do enforcement, on the other hand we're going to set up our own guest worker program, try to get a federal waiver, and establish ties with these communities in Mexico so we can get workers for agriculture. Right? They're trying to balance out two different things in a system that actually just, right, immigration system isn't suited to do that. I've actually written about this a little bit before, but it's just because immigration is a federal issue doesn't mean that we have to address it with broad brushes of national legislation. And one perfect example, and I don't know how you guys feel about Canada, but one perfect example is Canada, right? So Canada actually negotiates the federal government, so it's still federal power, but they go out and they negotiate specific accords with all their provinces. And every province essentially, not surprisingly, have different economic, employment, and interest needs, right? So, I always say, I mean, you have on Montreal, right? So you have on the one hand, you have Montreal, who's actually very interested in recruiting. They're trying to move into high-skilled workers on the one hand, but also French language-speaking populations. That's an ethnic issue. You have Toronto, that has sort of been very forward into sort of trying to open up a system in which they have unskilled and skilled laborers. But then you have Winnipeg, right? So Winnipeg is a rural population dealing with depopulation, right? And they have large rural industries. And their report is totally different. Their report actually focuses on the likelihood this immigrant will stay in Winnipeg, right, and build ties, right? And to the extent that they meet their sort of specific labor needs, which is rural and rural industry, right? So that system ends up recruiting from countries that are much more akin to where their economy is. And from what I understand, and I'm sure, it's been relatively successful, right? Winnipeg actually has done very well under this specific system. Toronto is relatively, and actually, to sort of add on to this thing, this is not just the federal government coming down and granting all sorts of concessions to the state. Because the state, like Toronto, right, province, like the Ontario province, in part of this negotiation, the Ontario province said, well, the federal government demanded, and the Ontario province said, okay, you give us these immigrants and we'll decide this group. And as a result, we will pay for this part of education, this part of whatever. So there was a bargaining that was going on, right? They're like, we need X, Y, and Z employers in our section. The federal government says, well, I don't want to pay them under my welfare state. So the province said, we'll take over some of that because we actually need the employment more than you're going to pay the province, right? So there's a lot more flexibility. It's hard to think about immigration, you know, the federal government negotiating, but I think you're already seeing signs of it, right? I mean, even before things started exploding, different communities like Iowa and Nebraska were already thinking about, is there a way in which immigration can help us? Different cities, Detroit, Pittsburgh, I've been looking at, is there a way that we can use immigration to revitalize our urban cities? I know I talked for very long, but let me leave you with one point. There's this great recent report that came out from Detroit about how immigration could potentially help Detroit sort of revitalize their base, right? And they go through all these things about how immigrants are great, and they revitalize New York City, and they sort of build routes, and they sort of use institutions and structures. And then they get to the recommendation section, right? The first recommendation is very broad. We have to make ourselves welcoming. You know what the second one was? The second one was, we need to advertise the fact that Canada has a great immigration policy and build ties because we're so close to Windsor that maybe they'll recruit people into Windsor that might cross the bridge and work here, right? But the thing is, right, that there was no other way to negotiate that, right? I mean, can you imagine Michigan and Detroit going to the federal government and saying, this is our specific needs, very different from what New York is facing or Arizona is facing, and, you know, we may want a different system. That's that's a more flexible employment. And the last thing is, like, we don't have, I mean, we have all sorts of problems. We don't have an economic policy, certainly not regionally, right? We've been having that problem for a long time with different flows around the country, Sun Belt, Rust Belt, stuff like that. We just don't have that even in the employment context.
Can I add something?
Yes, please.
I think that's a really interesting question. And I guess another way of thinking about it is that maybe immigration has always been a labor debate. It's sort of, in some ways, they've been so intricately entwined that it's hard to pull them apart. And here's what I mean by that. I just think that the debates have become more formal. Because if, historically, one of the big changes, right, that the law made was to formally restrict Mexican migration across the border. Right? So, because for many, many years, the restrictions on immigration didn't apply to Mexican citizens. So that and the reason for that was labor, right? There was a labor need, and so whenever whenever the labor needs increased, then enforcement would decrease in order to allow that flow to increase. And then and as a result of it, we ended up with this sort of cyclical flow that was talked about this morning, people coming back and forth across the border. But now, with more border enforcement, we're starting to see a more permanent population of undocumented immigrants, particularly from Mexico. And so employment discrimination rights become more important, labor rights become more important because that workforce is now more permanent. I think it's actually maybe even harder to pull those debates apart, but I think it's incredibly important to have that, to be having that.
Thank you, Julia. Did you want to add something, David? Okay. Other questions?
I guess I'll ask a question.
Oh.
My name's Jack Bender, retired attorney, Allstead, Kansas, a rural community. Lots of Hispanics in the area, but I haven't heard anything about the most popular thing or very newsworthy things going on in Occupy Wall Street. But I want to know, does any of this have anything to do with Occupy Wall Street? I've heard the labor people are getting involved. I'd like to have your views on this. Thank you.
Thank you. Who would like to address that first?
Well, since nothing's coming to mind, I'm going to defer.
I'm going to give it. It's hard to make the I mean, you can make the connection more broadly, right? Which is that to the extent that we have a economic imbalance of some sort, right? That we have some sort of system in which a lot of it, at least Occupy Wall Street would say, is not subject to regulation, that is sort of privileging capital. And as capital flows from different country to country, there's sort of a privileged class that can sort of negotiate that, whereas everyone else cannot, right? So in some ways, I think that's a part of it. I also want to throw out, since we start with Occupy Wall Street, I know every city has their own version of Occupy. But I think actually at the beginning, Occupy Wall Street has to deal something very specific with the labor market in New York, right? And I think that as you get more labor groups, especially sort of unionized Mexican, unionized Chinese, unionized Korean sort of groups getting involved in that regard, along with people who are college students trying to find a way to work, they're sort of exposing how much, this is actually following on Static Assassin's idea, that a lot of our sort of institutions, like New York City, is built upon a bifurcated system, right? So we have, on the one hand, broad masters of the universe that control the global capital flow from country to country, right? She would say, between London, Tokyo, and New York, and that sort of is going on. At the same time, we're using labor flows as a way to sort of offer the support system in order to service that, right? Because a lot of service needs comes out of that. And what that ends up doing is you can have a very, very prosperous city like New York City, generally, right? But at the same time, they have one of the highest inequality, along with the fact they have one of the highest poverty rates, right? It's funny talking to some of my, maybe I have a conflict of interest, my Wall Street friends in New York, right? And they're trying to convince me that, in New York City, 150,000, that's poor, you can't get anywhere with that, right? But at the same time, the poverty rate in New York has just climbed to 20%. So there certainly is people that are trying to get by in New York, right? As opposed to Buffalo, where I am at, in that. So I think those are coming out ahead. But I think the question is how much, and I don't think it's gone there yet, but is immigration going to be the wedge issue? Right? Is it going to be the wedge issue? And I think this is where a lot of different groups are trying to position it in different ways, right? I think with a lot of the union groups and stuff like that, trying to move into broader organizing of workers generally. They're trying to not have that as a dividing force. But I wouldn't be surprised if later on it becomes a dividing force, right? The issue why we have income polarity or whatever is not because of capital managers, but because we have, immigrant population flows hurting everyone else.
Thank you.
Yeah. It's not a good answer, but...
My name is Bill Rich, and I teach here. If we had had this conference 40 years ago with the same lead, I think, particularly dealing with state regulation of aliens, my guess is we would be focusing on the 14th Amendment instead of ranking laws. When I was discussing these issues a couple of weeks ago with a brother who's not a lawyer, but who lives in Alabama, his reaction was, what's going on there is all about race. And I wonder whether not only are we avoiding talking about the labor issues when we talk about immigration, but are we also avoiding talking about issues of race? And is there a way or a reason why, because of that history, it should enter into even our preemption analysis, or at least be reasons why we should be concerned about state regulation in this area?
Start with that. Again, great question, Bill. Thank you. I think, first of all, I think that there is a dialogue that's happening about race. It just wasn't the focus of this panel discussion, but there's lots of lawsuits that are percolating at the lower echelons or in the lower courts about that right now. The one interesting aspect why preemption has catapulted perhaps to the forefront of the discussion is an interesting point that Secretary Kobach made earlier, which is that the government is choosing to make that argument. The government could have brought all kinds of constitutional challenges, but the one it chose was preemption. And in part because of that, that is where a lot of the discussion is focusing. But a related point is that it's not clear whether or not the government got involved in the fight because of the preemption question so much as it got involved in the fight because of the potential race problems with race discrimination and equal protection, but perhaps felt that this wasn't the appropriate time to make those challenges because these laws haven't been put into force yet. And so I think in some ways the government is standing by to wait to see what's going to happen with the implementation of these laws, whereas the preemption challenges are a little easier to make at the threshold. So that's the only insight I have there.
You know, in the 1980s, employer sanctions law came into effect. There were three legs to that compromise. One was the amnesty piece of it, the other was the employer sanctions piece of it, and the third piece was the law would have been passed without this, and protections for minority employment discrimination protections. And so we ended up with protections with a new form of employment discrimination protection, citizenship status. But also an expanded national origin status, and the idea basically that the concern being that these laws are going to increase the level of discrimination against people of color, particularly Latinos and Asians. So, and in thinking about the E-Verify system, one of the things that these employers assign when assigning this up with this memorandum of understanding is that they're going to use the E-Verify system for all hires. And that's supposed to be a protection, against race or particular ethnic discrimination and national origin discrimination, because the idea is that employers can't say, well, we're only going to use this E-Verify system for people who I suspect are undocumented, so people who because their parents or their accent, I think might be undocumented. And so why would I use my energy to use the E-Verify system for somebody else? So I think it's a huge part of the conversation. But I think with the state's interest in ending the E-Verify system, I think a lot of the discussion around this is a way of talking about race without talking about it. Because once you start talking about citizenship status or immigration status or people who are undocumented, and you ask people to close their eyes and imagine an undocumented worker, right? That undocumented worker tends to have a particular skin color. It tends to be a Latino worker, and a particular socioeconomic class as well. So when that conversation occurs and we start talking about illegal immigrants or illegal aliens, I think that has a particular, that conjures up a particular ethnic cast as an image, and then people are reacting to that in some ways. The problem is that because we're talking about within the realm of immigration, we can use language that's race neutral and neutral. And so it becomes very hard to bring this stuff up. And the only other thing I want to say is that some of the error rates and the fact that the problem with the E-Verify system, this is the basic database errors, fall on minorities in particular. That's more what Rick's talking about being a structural issue, right? Because it's a disparate impact. It's not something that the creators of the E-Verify system said we're going to go out and get, people with with foreign last names. But because of the way that our society is structured, because of the way we think about, last names following a particular, right? The last name is only last, right? That structural system has a disparate impact, and it's not something that we really talk about at all when thinking about these kinds of errors. And yet it has a huge effect on U.S. citizens.
I'm just going to add real quick with an anecdote, maybe a warning. I think race is always involved. So what was interesting actually is the early equal protection cases, a lot of them actually had to do with immigrants who were also of a different race, right? And the Supreme Court was actually very bold in the early days in saying that actually the equal protection clause applies regardless if you're alienated, right? You could be a citizen or non-citizen, but it says it protects people, right? So for a long time, states were trying to do all sorts of things. All Chinese had to live in Chinatown, and you couldn't operate here, whatever. And the lower courts kept coming in and striking them down, saying this violates equal protection. At a certain point, what ended up happening was the federal government decided that they were going to pass, well, they enacted, and they always had, a racial naturalization clause. So up until about the 1950s, if you were not white, you could not naturalize, right? So that was perfectly racial. Now, it survived the Equal Protection Clause because they said the immigration power of plenary is so big, naturalization power, that, they can make these determinations, right, on the race. What ended up happening is, however, the states got smart, and they started writing into their laws, and there was a very famous series of cases. What they wanted to do was to ban immigrants who weren't citizens from owning land, right? Because a lot of Japanese were working agricultural land, and they didn't want them to work it. They wanted them to remain as tenant workers, but not become landowners, right? Actually, it ends up getting extended to sharecroppers. So these states like Colorado, California, rewrote their statute and said individuals unfit to naturalize under federal law cannot own land in the state. And then the Supreme Court looked at it and said, oh, that's just, the fact that they're piggybacking off of federal regulations is fine, right? The federal category is fine. The federal category is not racial because, it's I think not subject to the 14th Amendment. And it ended up insulating a lot of the states from doing so. But all they did was just piggyback off the federal label. So I think there are some backdoors when you think about immigration that may affect 14th Amendment.
So a little bit more to add to my last answer. On one level, the restrictionist states are making a rule of law argument that the federal government should be regulating this, but they're not doing it. And in many ways, these laws have come in response to the failures of the federal government or the Congress to come to some consensus in 2007. That is one of the important factors that is part of the bigger narrative about why now. But another important aspect is that the country is seeing migration from Hispanics into communities that were sort of untraditional. So in places like North Carolina and Pennsylvania, there's an influx, a new influx in the last several years that led up to this sub-federal immigration revolution that also has a lot to do with all of a sudden why states are interested. And so the conception, and probably a quite accurate one, is that it's not just about rule of law for these restrictionist states, but it's also a reaction to this new cultural diversity. And insofar as the reaction is grounded in racist or ethnic or cultural diverse sentiments, Cristina Rodriguez has argued that that's a reason why perhaps this is a good dialogue to have, and tying it to preemption, and why we should, both legislature, both the government, the court should not rush, at least not in any kind of hair-trigger response, to say states can't get involved here because the federal government has exclusive power, because the result of that kind of a hair-trigger response might be to submerge what otherwise should be an important conversation in our country about things like race and cultural diversity. So that's a perspective that, if I'm reading her insights correctly, not mine, but I do find that to be interesting and directed at your comment.
I have a quick question. Some have expressed the concern, of course, that these laws are going to permit employers to avoid their obligations under the Wagner Act or under the Fair Labor Standards Act or under the anti-discrimination laws. How real do you see that? How realistic of a problem is that?
I missed the beginning of the question.
To repeat the question.
All right.
Some have expressed the concern that these laws will enable employers to avoid their obligations under the acts that Rick was referring to earlier, for example, the Wagner Act and the obligation to bargain in good faith, or the Fair Labor Standards Act and minimum wage and overtime laws and the anti-discrimination laws. And I'm wondering to what degree you think that there's a real danger that they will be used in such a way.
So I think there is a real danger, right? But it's a little tricky to get there, right? So because if the idea behind implementing employer sanctions laws, right, is to sort of cut off that, right, that magnet. But the reality of the employer sanction scheme is that it allows employers to hire an undocumented workforce and know who it is. And I think you do have that danger of having an employer who has the kind of leverage that they need in order to get around those laws. And if your undocumented workforce is sufficiently large enough, it makes it much more difficult for people who are in the workforce who do have all the status or authorization to work to do the kind of collective action that one would need, or to complain about minimum wage laws, because if they're concerned that they might be fired, and an undocumented worker without that kind of leverage hired in their place, then nobody's rights can be truly enforced. And that was one of the big complaints about the Holland Plastics decision.
The literature I have read has already suggested that danger has been around for a while. That actually, so Vernon Briggs, who's a labor economist, has written a lot about how, now he comes to a different conclusion, but he has written a lot about how during times of high immigration, that unionization and organizing become much more difficult. He posits it's a racial or ethnic issue, or maybe just the fact that it's a lot of low. I think a lot of it is the susceptibility of immigration sanctions, right? When you have, so you guys heard about the child Hershey's revolts, right? But when you have, on the one hand, undocumented immigrants that don't have any rights, on the other hand, you have a lot of temporary workers who are tied to their employers, right? So they're not unionized. These become very attractive, right? Because you avoid all these laws. And the attractiveness is quite interesting because there was another economist who wrote about this, and he was doing assessments. And the general conversation that we usually have is people hire undocumented immigrants just because they get paid. You can pay them lower wages. I think for some that's true. But he actually found that undocumented immigrants weren't getting paid that much lower than documented immigrants. And his conclusion is that the reason is because there must be something else about undocumented immigrants that is desirable for employers, that even at the same wage, they'd rather hire undocumented than documented. Now, maybe we could talk about, do they work harder or whatever, but part of the reason they work harder maybe because they're in a vulnerable position, right, whether in regards to making any claims. But I think, even taking the wages apart, I think there's already, in the common literature, there's already rational capital being made, and it's been made for since 1965, according to this literature. You see the curves.
We have time for maybe one more question. Anybody? Okay. Would you like to take a minute just to wrap up? Each one of you make one final point, or do you feel that you've said what you want to say? Dave, I know you always have something to say.
No, I wasn't told everybody where the party is tonight. You guys want to wrap up, or no?
Come to the party.
Yeah, so I think it's been a long day, and I want to just thank everybody for being here. And remind you that this evening the bar will open at 5:30, and we have Peter Schuck coming for the reception buffet, and it's going to be a great event. So everybody who's registered, I look forward to seeing you there. It's at the Capitol Plaza Hotel in the Shawnee Room, and again, thank you so much for joining us today.
Not to be outdone, I too have presents to give away.